This webinar will be a short introduction to a fairly ticklish topic, the topic of adjournment of capital claims. I am Cordelia Williams. I'm a barrister at Pump Court Chambers. I specialise in private children and financial remedies work. This webinar will be about half an hour. Please feel free to start your lunch break early if you were late on because of the delayed start. We'll spend a few minutes to take some questions at the end, as much as we have time for, including a few I've received in advance. But if you do have any questions as we go along, please do send in the Zoom chat box. I'm going to focus on practical questions of when this is relevant for your cases. And in the handout that you'll receive shortly after the webinar, I've listed some of the key authorities. So you don't need to take a note as we go along. They're all listed at the beginning. I've also included a reference to an article that I co-authored with Edward Boydell of Pump Court Chambers, which was published in Family Law Journal of April this year. That also goes through the case law in more detail. I would also refer you to a podcast that we recorded at the end of last year, the December 2020 episode. That's the Family Law podcast produced by Pump Court Chambers, in case you want some more listening on this subject. This fairly niche topic was one I became familiar with when I represented a client in 2017. We all regularly see cases where a respondent to financial remedy proceedings doesn't provide proper disclosure and or fails to engage. And I was for a wife in one of those cases. Husband had failed to provide proper disclosure for pretty significant capital assets, including apartments in Dubai, a business and US bank accounts. He had filed an incomplete Form E and then chose not to engage further in proceedings. I asked the court to transfer all the English properties to wife and to adjourn her lump sum claim to await a clearer picture of husband's capital interests, particularly abroad. As before, recorded Amos QC at the CFC. He was satisfied, firstly, that there were very considerable assets that husband owned but had failed to properly disclose. And two, he agreed that it was an appropriate case to adjourn wife's lump sum claim indefinitely. Now, that is a rare outcome. However, careful reading of Section 25A of the Matrimonial Causes Act is helpful, because, of course, the court is compelled to consider a clean break, but there's no automatic presumption in favour of a clean break. We look at the wording, and I'm quoting, "It shall be the duty of the court to consider whether it would be appropriate so to exercise its powers that the financial obligations of each party towards the other will be terminated as soon after the grant of the decree as the court considers just and reasonable." So, of course, there are circumstances when a capital clean break may be inappropriate and actually unfair. Adjourning a capital claim is then an important option to bear in mind because it can sometimes be the only proper solution. So, question number one on everyone's minds joining today: when is this an appropriate solution for my case? Well, the first very obvious and perhaps the most common category is one of non-disclosure. This was the one that I was familiar with, where one party is deliberately putting assets out of reach. Those are circumstances where you need an adjournment of the other party's lump sum claim to await a clearer picture of the capital assets or to await unlocking of future resources that have been put out of reach. Many of the examples in the case law rely on a specific circumstance or a foreseeable event which, once it occurs, would allow capital to become available. So specific circumstance, foreseeable event, which would allow the capital to become available. Pretty niche. Or the court being satisfied that there are meaningful assets which might be available, but which haven't been disclosed. So pretty important there is to be able to have sufficient evidence to persuade the court of ownership in the first place. Examples of the first situation, so specific circumstance or foreseeable event, which once it occurs allows capital to be available, can be where there's expectation of a certain inheritance. has to be a bit more narrow than just general inheritance. And an example of this was in the case of Hardy and Hardy, 1981 case, but still good law and often referenced as one of the leading cases in this area. Mr. Hardy was the son of a famous bookie and racecourse trainer, and he worked in the family business, ostensibly as an agricultural worker. But the court was persuaded that Mr. Hardy's income was artificially low and that he actually had very substantial expectations of wealth. His father was only paying him minimum wage. That wage had no bearing to the matrimonial standard of living. And at the time of the proceedings, Mr. Hardy Sr. had collaborated with Mr. Hardy Jr. to ensure that there were very few capital assets available within the court's reach. I can't take credit for Edward Boydell's pretty pithy description of this, but the conclusion of the court was that it didn't like Mr. Hardy's disguise as a man of straw, knowing there were countless bales of straw in the barn. Lord Justice Ormerod said the only way that the court could be satisfied that wife received fair financial provision was to indefinitely adjourn her application for a lump sum. One more recent example, Joy and Joy-Marancho, 2016 case heard by the late Sir Peter Singer. A trust position was found to be an elaborate charade, and that one day that elaborate charade would re-establish husband's access to trust assets. That same case returned in 2019 before Mr. Justice Cohen, then reported as Joy and Joy. Wife's capital claim was adjourned for a second time, now until 2022 it's remaining live, but her claim will be dismissed if there's no capital application made by then. Helpfully, and I'll come on to this at the end when I talk about some practicalities, Mr. Justice Cohen ordered the husband to provide disclosure in the future to help the wife assess the merits of reviving her claim. And as I said a moment ago, when I come on to practicalities, I'm going to recommend that as a really helpful direction to ask for if the court do adjourn your claim. And Mrs. Justice Cohen in that case said, "I'm dismissing the wife's claim against this background as a matter of last resort. I am not so pessimistic about the future ability or likelihood of husband receiving funds that I am prepared to take that step. I therefore adjourn wife's capital claims, but I will say this, they were to be dismissed unless an application to restore them is made by 31st July 2022. The most recent case where there's an example of this situation, to remind you, specific circumstance, foreseeable event, which would allow capital to be available. Case of AW and AH, 2020 decision. Mrs. Justice Roberts considered there was, quote, a reasonable probability that he, husband, may restore a measure of financial equilibrium in the future. In that case, husband had been very wealthy, the parties had a very high standard of living during the marriage, but he had been made bankrupt some years previously. And the court found significant deficiencies in husband's disclosure. So Mrs. Justice Roberts held that despite, and I'm quoting now, the imperative to achieve a clean break between the parties involved in this type of litigation, insofar as it's possible following divorce, this is not a case where I can achieve a fair outcome other than by adjourning this wife's claims for lump sum and property adjustment orders. I'm as confident as I can be that husband will do whatever he can to re-establish his financial base, although I have no expectation he will secure in future a return to the scale of wealth he previously enjoyed. I would say the important red flags to bear in mind are the clear themes that run through these leading cases, which are bad conduct by husbands, almost exclusively in the reported cases, who are disagreeable characters who've ticked off the judge, combined with wives who have real needs and the expectation that husband will receive a quantifiable sum within the foreseeable future. So bad conduct, husbands the court doesn't like, wife with real needs, and expectation that husband will receive quantifiable sum in the foreseeable future. In these circumstances, courts are likely to adjourn capital claims to allow justice to prevail over finality. The second situation, other than only non-disclosure, although of course they can come hand in hand, where this sort of solution is appropriate, can be relating to valuations. And I've already had a question in advance on this subject that I'll address at the end, in relation to the pandemic particularly. Adjournment of a capital claim has been raised as a possible solution where a business valuation is disputed. Mr. Justice Francis in O'Dwyer and O'Dwyer, a 2019 case, we remember is the case that applied Waggett to say that it's now settled law that future earnings are not subject to sharing. Quote from Mr. Justice Francis in that O'Dwyer decision: "I agree it would have been possible for the judge, had he thought it right to do so in the exercise of his discretion, to award the wife a capital sum in respect of her half of the business, together with some form of balancing payment in the event the business sold for a substantially different outcome than the agreed value. It'll be a rare case when it's appropriate to do this, having regard to the statutory steer towards a clean break." I pause there. So that's another option, not adjourning the lump sum claim, but making a lump sum award for her half of the business with a balancing payment to follow if the business sells for a substantially different amount. I'm carrying on the Mr. Justice Francis quote: "Alternatively, in rare cases, the court can adjourn the lump sum claims if it's thought appropriate to do so, for example, when ascertaining value is extremely difficult." And that is particularly relevant here when it comes to valuations being extremely difficult and the court not having a clear idea about what the capital is to be able to then go on to make a fair lump sum order. Second key question you might be asking: what's the normal duration of an adjournment of a lump sum claim? Well, that's a tricky one to answer because there is no normal time frame. The time limits that courts have imposed in the reported cases vary wildly, from fairly soon to 7 years to indefinite adjournment. So there is no rule really about what is an appropriate length of time. It does just depend on the facts. The facts that it particularly depends on is the nature of the future resource that the court has deemed that will become available and when it's likely to be available. So the nature of the resource and when it's likely to be available are your two best steers in ascertaining the timeframe you invite the court to adjourn your claim for. Mr. Justice Mumby, as he then was, said in C&C, a 2010 decision, "An adjournment should be directed only if the property in question is likely to become available in the near future or within the next few years." I must say my view is that since that 2010 decision, the case law has softened the circumstances in which it's appropriate to have an adjournment and also softened the timescales that Mumby gave in that case. The reason for that is perhaps obvious. The main context in which these solutions are appropriate is non-disclosure cases. And in non-disclosure cases, we know that it's usually impossible to predict when capital assets are going to become available, because how can you know in the first place? And that was the situation that the court found itself in Kwan, the case of Kwan and Bray, as I said, the references on the handout. The husband had been guilty of brazen non-disclosure, said Mr. Justice Mostyn. It's a good authority to have a read of. I must say it's a particularly pithy one, as Mostyn is prone to producing. The court found that the husband's evidence had been, quote, "dishonest, manipulative, arrogant, menacing, and contemptuous of the court's authority." So falling squarely into this category of unpleasant husband who the court doesn't like that I mentioned earlier. And the court found that this justified an indefinite adjournment of wife's capital claim, so no time limit put on it. Mostyn said, quote, "While generally capital claims should not be left indeterminately unresolved, there are hard cases such as this, where fairness and justice must prevail over the normal desirability of the finality of litigation. So use that reference there if you do have a case where, because of issues of non-disclosure, so not because of your client's fault, it really is impossible to put a timescale on when it will be appropriate for the case to come back. Practicalities now. The important thing in terms of the timeline is to consciously decide before you've even issued, if you're assuming you're the applicant, whether it's appropriate to pursue an application for a lump sum order in the first place. So when you're completing the Form A, it needs to be remembered a party isn't obliged to bring an application for capital financial provision at all. And of course, we'll all be well aware the court has the power to make one order for such lump sums or sums as may be specified. Of course, it can be payable by instalments, but you only get to fire that shot once. There may then be circumstances where a more focused and targeted claim, or no capital claim for now at all, is actually a better strategy. And this is something that needs to be particularly considered pre-proceedings, to ask the question, is it beneficial to apply now for a lump sum, or actually is delaying a lump sum application more advantageous to my client? Once you've got past the Form A stage, of course, it may then become the obvious answer, but only at that stage. However, it might be appropriate, for example, if you have voluntary financial disclosure, if that financial disclosure is unreliable or completely at odds with the claiming spouse's knowledge of what the actual resources are, it might be appropriate to seek spousal periodical payments and perhaps also, or a property adjustment order, but deliberately not apply for a lump sum because of the concerns about the disclosure produced. The impact of the pandemic may also influence the decision. Many businesses, as we know, have been badly affected. So parties may need to make a financial remedies claim to have finality and to have other orders made, but choose to delay the capital claim where the value of a business or other capital asset is expected to increase post-pandemic. As I said, there's a question about this that I'm going to address in a moment. A couple more practicalities first. No separate applications necessary, in my view. Of course, you must signal your intent at the earliest opportunity that a deferred claim is what your case is going to be. And lastly, if you do have an adjournment, consider whether it's helpful to seek a direction for future disclosure. This was a direction made by Mr. Justice Cohen in Joy, the case I mentioned a moment ago, and it can be really helpful to know when to revive your capital claim, because often otherwise it's entirely a stab in the dark about when assets have increased in value or are now available. I'm going to address the 3 questions that I've had in advance. Please do tell me if there's any other questions as we go along, and I'll keep an eye on the chat after I've addressed these 3. They're 3 really helpful questions, I think. 2 of them particularly, I think, might be applicable to a fair few of you. The first is in relation to cladding issues on blocks of flats. The question is, reference to ownership of various flats with cladding issues, which may result in negative equity, would be helpful. Clients with various properties, including rental flats, where illegal cladding and there's an expense to replace on a tower block, which is currently an unknown entity. Neither party wants to be left with the flats due to the high risk. Now, my thoughts about that. Firstly, this seems to be a similar position to the negative equity cases of the early 1990s. Usually in those cases, it was one or the other party living in the property, and they then chose to retain it. Making it applicable to the cladding cases, I suppose that either there may be a significant debt left, or alternatively some bailout from the government that might reduce the owner's losses. I suspect that this is a tricky answer, but each case will need to be considered separately to achieve fairness. And some of the solutions that might be required are reverse contingent lump sums, perhaps, indemnities, or other undertakings and orders. But yes, in conclusion, it might well be that an adjourned lump sum might be appropriate in a case such as that. The second question I've had is about pensions. It says adjourning pension claims to cover the pensions gap where a pension is in payment, but then cannot be paid to the beneficiary of the pension sharing order annex until a later date. I'm not sure I understand that connection, because if you adjourn the pension award, usually you make a periodical payments order, and often you need to make a lump sum order at the same time anyway. So I wouldn't say that there's a particularly obvious link between that and adjournment of a lump sum order. Last question that I've had in advance, is this really going to be allowed save in very unusual circumstances? Just because you hope the assets will go up in value, that would not normally even come close to being enough. So what evidence of arise is going to be needed, and how imminent/certain does it need to be? I absolutely agree, it would need to be unusual circumstances indeed, if the court is simply waiting for assets to go up in value. And I would say that's unlikely to be enough to justify adjourning a capital claim. We've seen recently the COVID cases where there's a difference in the value of a business were being reported, and that hasn't been enough to be a VADA event. So I would say this falls into a similar category. It's not impossible, but to me, it would be very unusual circumstances indeed, where you're simply waiting for the asset value to increase. I think to focus it more on the core of this topic, at the heart of this area of law is usually the activity of one of the parties trying to manipulate the court. So whether that's manipulating the timing of the application to suit them or concealing their true wealth. That's a usual rubric of facts where this situation is an appropriate solution and why it can be fair to adjourn. So that is very different from simply a delay to wait and see if valuations will increase. I hope that addresses the COVID relation to this particularly interesting area and how I think it might be more applicable in the near future. Does anyone else have questions? I haven't received any further ones, but I'm conscious that the 3 questions I had were perhaps particularly well targeted ones and might have addressed some of the queries you had as we were going along. I'll give it another moment. How will this affect someone who's ill, life expectancy of 5 years? I would say that's more in a context of seeing how that will affect somebody's needs, because life expectancy, unless it's life expectancy with then a certain inheritance on one of the other parties, I'm not sure how that's going to be directed to the same context as an appropriate situation for an adjournment of a capital claim. In terms of inheritance is tricky because, as the Hardy case shows us, it has to be a pretty certain inheritance, and in the Hardy case it was linked to an inheritance where if Mr. Hardy Sr. had written out Mr. Hardy Jr. from his will, there would almost certainly be an inheritance act claim because Mr. Hardy Jr. was so involved in the running of the family businesses. So it's not a situation where you can automatically say, well, you know, somebody's relatives are in their old age and in poor health, so therefore we need to wait to see what will be received in the inheritance. That will remain speculative, and I imagine remain a questionnaire question that you've got to justify pretty accurately if you want to see somebody's will. In terms of future questions, I'm conscious of the time and that this was billed as a strict half-an-hour time frame, so please do email me if anyone has any additional questions. My email address is c.williams@pumpcourtchambers.com, c.williams@pumpcourtchambers.com, and Clark Sean will send you the handout that I'm sorry that I wasn't able to send around to you today. Zoom has been a total nightmare this morning, and he will also include my email address for any further discussions that you wish to have. Thanks for everyone for joining me today. I hope you found it helpful, and please do get in touch if you want to discuss further.